Hi, good afternoon, and welcome to Resolving Onboarding Mistakes That Cause Legal Problems on Federal Contracts. I'm Nicole Atala,
And I'm Sarah Nash.
and we are with PilieroMazza. You can read our bios at your leisure if you're really interested in it, but the long and short of it is we are labor and employment attorneys at PilieroMazza. I am a partner in the group. Sarah is my trusted colleague and knows just as much about everything and more. And we thought, after a lot of questions involving legal issues involving onboarding, that we would have a webinar that addresses what you should be thinking about at the onboarding stage that can help you foresee labor and employment landmines and how to avoid them. And so you see, so you won a contract, now what? Congratulations, right? So now all of the really hard work begins. But many investigations and lawsuits stem from things that you're not thinking about when you're onboarding folks. So today we're going to identify how to spot concerns and what to do about it. And hopefully as we go along, we've kind of a lot to cover about a number of different things today. So it's kind of going to be a high level issue spotting exercise. We hope it'll be fun. That's part of why we wanted to do this webinar. And if you have questions along the way, please feel free to send them to us via your chat function and the Q&A function, and we will get to them as soon as we can. If we don't get to them, we will respond to you afterwards. All right, let's get to it. So the first thing we want you to think about is be classy and classify, right? So we want you to, before a bid goes in on any type of project, work together with your pricing team, should be working with your HR team to think about things like, are these folks exempt or non-exempt from the Fair Labor Standards Act, which basically is the law that says you have to pay overtime or not overtime, and that can affect obviously how much you're budgeting for each particular employee. The law is changing on January 1st of this year, and the salary threshold for exempt folks is going up to $684 per week. So if you haven't looked at whether that will affect your exemptions, now is probably a good time to be doing that. You will likely not be able to get much of a price adjustment if you have folks that are affected or your bottom line is affected from this legal change. It's going to be very difficult to get a price adjustment. Some folks, it's not a ton of price impact for a lot of companies, but I get that question from time to time. It also is important that you classify exempt versus non-exempt, not only for salary versus hourly and overtime, but because it can affect whether you are obligated to pay prevailing wages on a Service Contract Act or Davis-Bacon Act contract. So it's really important that you're classifying people correctly. With respect to prevailing wage, it's also really important that you're classifying folks correctly because you have to classify them in the appropriate prevailing wage classification as well. So if it's a Service Contract Act, it goes into one of many of these job classifications on the Directory of Occupations, and Davis-Bacon, you're going to be looking at the classifications on the wage determinations as well.
Right. And so as you're thinking about all of these things, you want to be kind of considering the workforce that you're looking at. And often a lot of those workforces, especially under the Service Contract Act, are going to be unionized workforces. And so generally when that's the case, there's this additional level of doing your due diligence and reading CBAs, making sure that you have a good understanding of how people are classified. Because unlike with some perhaps different contracts that aren't unionized, there is an additional level of bargaining power that employees have and that unions have over those employees to make sure that terms don't necessarily change without negotiation. There are some very big caveats here that I believe that we'll discuss later in the webinar. But essentially, you just want to make sure that you're reading everything that is included in sort of the relationships on how employees interact with the workforce.
All right, next slide.
Let's do it.
Don't jump because the incumbent did. So often what we hear from clients is we'll get a phone call and someone will say, Nicole or Sarah, I know that the incumbent classified everyone as exempt? And the first thing we're going to say is yes, but did you do your own classification, for example? Or the incumbent organized work in a specific way. And so we want to organize work in a specific way. Now, you might be required by contract to organize work in a specific way or to categorize work in a particular way. But don't assume that because the incumbent paid certain wage rates or handled their benefits in a certain way or classified folks in a certain way that you are supposed to be doing the same thing. So you might have some intelligence, you might have gathered some information from employees, and the question is, how do you use that? I would likely give you the advice that you should be using that to inform what employees will expect of you when you walk on site. You need to make your own decisions about whether you are going to conform to what the prior contractor did, but it's a reasonable bet that employees are going to be expecting something similar. And if you don't meet that expectation or discuss that expectation with them, that's the reality, that is where you get some of those Department of Labor complaints and EEO complaints.
And a big part of this is going to be, I feel like a broken record sometimes. We talk about this all the time, reading your contract, because just because it's in your contract doesn't mean it was in the predecessor's contract. And so there can be very big differences between how the work is organized, how the government wants the work to be performed, that really might influence how you're kind of going to proceed. And on that same note, maybe this is a good time to talk about the non-displacement of certified or of qualified workers.
Sure.
Requirement, which was just revoked. So I think Nicole can maybe quickly teach you about it and then quickly tell you to erase it from your memories. It doesn't really apply, but there are some interesting lessons to be learned.
Yeah, so essentially, if you weren't familiar with the non-displacement rules before, it essentially said that you had to, for service contracts and Davis-Bacon contracts, you had to hire the incumbent workforce to the extent you had the positions to fill. The Trump administration just revoked that. Practically speaking, you will likely still be picking up, predecessor workforces, but even under that rule, you did not have to provide the same wages, benefits, the same number of jobs as the incumbent did. So it's still very important to understand that just because the incumbent did something doesn't mean you need to. That's particularly relevant with respect to collective bargaining agreements, as Sarah mentioned earlier, making sure that you're clear, and I think we touch on this again later, that you're clear when you're going on site as to what types of wages and benefits you are going to adopt, and whether you're a clear successor is really important when you're dealing with a unionized workforce. You also need to make sure that you don't assume things like citizenship for the employees that you're onboarding. And we had a situation not terribly long ago, last fall, where a client brought an employee on and they kept making excuses about their I-9 paperwork. And the client gave them the benefit of the doubt because they were employed by the predecessor contractor. So there was an assumption that E-Verify had been done and that the paperwork was truly just missing. But the reality was this person could not come up with the paperwork. And because of some quirky California laws, we had a weird wage payment issue. So it's really important that you're following all the steps that you would for just somebody that was walking in the door. Is all of the onboarding paperwork complete? Did you need an application? Did you not need an application? Complete all of those processes from the outset, and don't assume that because the prior contractor was employing them that everything's going to be a-okay fine.
I'm going to pipe in with a quick EEO message as well. You want to make sure that you're applying your kind of rules and your rules and policies across the board, right? So even if you're 100% certain that Mike has all his paperwork in order, you can't give him an exception, because you don't want to be in a situation where you're treating some employees more favorably than others. And so a really easy way to get people to comply with policies is just say, no, this is the policy, we can't make any exceptions.
We have one question that I think would be good to address now, because we just talked about classification under the Fair Labor Standards Act, but the question was, if essentially someone is classified as an exempt and it's stated in the contract that they're exempt, or a government, say the contracting officer, tells us in writing that the position is exempt, can we classify the person as exempt? And the short answer is no. That's not a defense for the Department of Labor that the contract said that they were exempt or that a government official said they were exempt. Now, might you have a claim for your cost to the government if they in fact made it a term of your contract to classify somebody as exempt when they really were not in fact exempt, or the Department of Labor says they weren't exempt? You might have that ability depending on where this was said, but the Department of Labor is not going to consider that as a defense. You will still owe back pay for overtime if you misclassified.
Yeah, generally, it's always going to be the company's obligation to decide classification issues, not just when it comes to exempt versus non-exempt, but where you're putting people under what classifications under the Service Contract Act and the Davis-Bacon Act. And it's not always an easy task, but one thing that we recommend is that you fill out a worksheet that should show your work, right? It's what every math teacher has been telling us in second grade. You want to make sure that you're writing down your decision making, so if DOL does come, you have a really good reason for why you classify it a certain way, and saying, well, the government told me to isn't going to be one of those good reasons.
So what happens when you're the new kid in town, right? So what we see often is Department of Labor or EEO complaints that come because you have these tenured workforces. You're often hiring folks that have worked on a contract for a significant amount of time, and there might be a little bit of new contractor hazing going on, right? These folks have a certain expectation about what's been done in the past, how they like things done, and if you upset the apple cart, you could have either disgruntled workforces, it makes it harder for your PM, your customer starts getting upset because the folks that they've worked with for a long time are not happy. Not that it's important that everyone be happy, but what's important is that expectations are clearly communicated and that you meet people kind of where they are. And this is, of course, a soft skill. It's not something that always comes easily, but a smooth transition is generally good for everyone. The other thing you want to keep in mind is you might be contacting incumbent employees to talk about the transition when they're still working for the prior contractor. This can cause some concerns by the predecessor contractor, the incumbent contractor, about disrupting their work, right? They might still have a period of performance that is not completed yet, and they might not want your folks calling their employees. This could be particularly true if there's a bid protest or something going on where they are not completely confident that you will in fact be the awardee at the end of the day. So you want to be careful, if you can, to contact incumbent employees when they are not on working time for the current contractor. You want to avoid claims that you are interfering or tortiously interfering with their contract and costing them money. So an example of that might be that you expect a 1 month transition period. You are currently working to make that transition happen and are contacting their folks. And if somebody jumps ship and goes to work for you early and the other contractor feels like they have a tortious interference claim of some sort, they could potentially be entitled to damages for the period of time, that they would have otherwise expected that employee to work for them until they transition to you. So you want to be careful about that. You want to also be careful about non-competes and non-solicitation agreements. So there might be questions about whether those non-compete and non-solicitation agreements that the incumbent employees have are even valid once that contract is lost by the former contractor. But if you know that somebody has a non-compete or a non-solicitation agreement, it might be worth checking to see to what degree that they are valid, because that can also lead to tortious interference claims.
Right. And generally, these agreements need to be very narrowly tailored. And so, if they weren't drafted in that way, there are some states and some situations where they're not going to be enforceable, but it's always good to look at the language. Another question that kind of comes up in this world is the impact of we just talked about it, the non-displacement of qualified workers. That used to be a really good sort of requirement that a successor contractor could point to when they're coming on board and explain why they're talking to an incumbent's employees, explain why they have an obligation to bring on their workforce. And it was a really convenient way to say, we're here and we have this obligation. Now that it's not there, it will be interesting to see how this kind of shift of work from the incumbent to the successor is managed, and whether there are some additional situations that might pop up.
Yeah, normally we would say that once that prior contractor loses the work, they lose a lot of their ability to enforce the non-compete agreement. But again, these are very factually specific scenarios that have to be evaluated on those specific facts. So we couldn't say all the time a non-compete is invalid, going from one contractor to another. There are lots of different ways that it can be valid. So you want to be careful, and it's always a good idea, I think, to, in your offer letters or somewhere along the way, confirm that somebody does not believe that they have one, and if they do have one, that somebody's looking at it. You also want to be careful about things like ban the box, what types of questions are you asking folks that you are onboarding, whether or not you're hiring new folks that have never worked on the contract or incumbent personnel. It's really important that you understand that in certain states, you can't ask things pre-offer. You can't do background checks pre-offer. You're not supposed to ask questions about protected class issues, about disabilities, things like that should not be asked pre-offer. Background checks just happen to be one of the particular sensitive areas because a lot of states have ban the box laws that limit your ability to ask about arrests and convictions prior to an offer.
Right. And then once you are able to consider those arrests, you want to make sure generally that they're tied to the type of work that the employee's providing, the type of work that they're engaged in. There are a bunch of considerations. And I mean, generally, this is sort of the opposite problem that you have of following the incumbent and doing whatever they do. Generally, you can probably assume that they have followed these background checks and have background checked everyone. But again, look at your contract, make sure there aren't additional requirements that you have to impose to make sure that you're kind of complying with those requirements.
Yeah, I mean, you never know. I mean, somebody could have gotten in trouble while they were working for the prior contractor. We have had some really interesting arrest issues over the years where someone working on a contract was arrested for conduct off of the work site, and at what point in time can you terminate them? So you generally do want to be aware of this. The same frankly goes with Googling. I generally don't Google pre-offer. There's a lot you can find out about somebody that can sway your opinion of them, and some of those issues might be protected class issues, and believe it or not, you can, people find out by word of mouth, that maybe you withdrew your consideration of a person because of something you found online.
Some states also prohibit you from taking action against an employee based on an arrest.
Yeah.
So just because someone's been arrested doesn't necessarily mean that you can take an adverse employment action against them. So you want to be careful about the states you're operating in and what assumptions you're making about what's allowed and what's not allowed.
Okay, so the next sage piece of advice is dig deep and do your research. It's important to know when you're onboarding folks and talking to them about what offers you might give to them, how were they paid? Even the frequency with which they were paid. Were they paid, every other week on every other Friday? Were they paid weekly? Were they paid, what payroll schedule will they be on? If folks really are concerned, the majority of questions are about, how long it's going to be before we get paid, right? So if you're in a state there are a few states that still allow employees to be paid on a monthly basis, and asking people to go from getting paid every 2 weeks to a month can be a big jump, right? So those are different ways you can figure out in advance how to message some of those changes to folks. What benefits did they receive? You would be shocked at the number of employees that are really upset. I mean, really upset when their benefit offerings are changed. It may be the same level of benefits, but benefits are hard to describe. So some folks are really sensitive about, the type of benefit offerings they get. So knowing what they received before you came on board in those initial conversations can be really helpful, because you will have already thought about messaging. We don't offer the same types of healthcare plans, but we offer, 2 plans that do have comparable benefits, and let me show you what they are. And that will really streamline that process for you.
It's especially relevant in the Service Contract Act and Davis-Bacon Act world, where often employees are paid cash in lieu, which means that you're paying out their fringe benefits in cash. So they're getting that additional $4, $5 an hour that's going straight into their paychecks. If a successor contractor comes in and switches that to health benefits, maybe vision, dental, the full works, it's going to be a big adjustment to the employee's wages and to their expectations. And it doesn't mean you can't do it. It just means you should be sensitive to sort of the types of changes that are going on.
And in those types of scenarios, when employees were getting cash in lieu or some other type of benefit that they really liked, and they feel like you're taking it away from them, you will often get feedback. Well, it's my money. The Service Contract Act says that I get $4 and change an hour. I get to decide what I want to do with it, and I want it in cash. But the reality is that it's at the employer's discretion how to use those funds. And, there are good ways and not so good ways to message that. But essentially, the employer does have control over that. You just want to make sure that you are able to explain it in such a way that that employee doesn't run off to the Department of Labor and complain. Because the reality is that if the Department of Labor gets involved, they might clear you on the benefit side pretty quickly, but they're going to investigate the entire contract, wages and benefits and overtime, and may very well find something that they don't like. You also want to think about, are there employees you don't want to hire or vacancies? Because their contracting officers often have some folks in mind that they didn't particularly love, or folks that they think are essentially sacred to them, that they don't want them upset in any way, shape, or form. And it's good to have some idea of whether there are those folks that are on the contract, so you can maneuver any problems in advance. So for example, if there's somebody that the contracting officer really, really loves, but you don't really have the confidence that they can do what you need them to do, or you've heard, some not so great news about them, you might need to do some work with the CO before you decide not to make them an offer, so that your customer isn't angry out of the gate.
Mm-hmm. On that same sort of note, though, you also don't want to, even though the non-displacement of qualified workers requirements aren't in place, you don't want to make a decision that's ultimately based on a discriminatory decision,
Absolutely.
Right? And so you still have an obligation to make offers to employees without bias because of a protected class. And so as you take the customer is not always right in this situation. And so you want to make sure that you're making them happy, but also complying with your obligations as an employer under EEO, OFCP, CCP requirements.
And where we see the most of this is usually in the Americans with Disabilities Act context. You'll kind of start talking with a contracting officer, and then all of a sudden they're like, this person's never here. We don't want them, you have to find somebody else for this spot because they're just never here. And then when you're doing some digging, you figure out that the person has a disability and has been working from home, and that was accommodated before, but apparently it seems troublesome for the contracting officer now. But you don't want to be the fall guy for that. So you want to make sure that you are diligent when you find out those details.
We just received a question whether we'll be discussing construction contracts as well as service contracts. Some of the reasons that we've been focusing on the SCA is because it has some weird, quirky kind of rules that come into place, but generally most of what we're discussing also applies to the construction world. You want to make sure that you're following these sort of steps to, like, it really, not just construction, like any sort of contractor. Yes. When you're making a bid, you want to be thinking about all these considerations.
And that kind of leads us to, whether there are employees on leave, and this would apply generally across the board, but USERRA is the Uniform Services, essentially military leave law that says that if somebody goes out on military leave, that leave is job protected and they get their job back when they return, if they return within 5 years and go through the correct application steps. Why does that apply to a contractor? Well, you are a successor in interest under a number of different laws, even though you are not the same employer. So if the prior contractor had somebody on military leave and they did not come back or return before that contract ended, you as the follow-on contractor likely still have an obligation to return them to the position that they had before they left. So you might have to backfill that position temporarily, but you should understand that if an employee comes knocking on your door and says, I was on military leave, now I'm back, I want my job back, you're the contractor that holds that spot, you may well have an obligation to return them to their spot, even if it means displacing somebody that is in that spot now, which is very difficult to stomach, I think, sometimes.
Yeah, it's not one of those intuitive things that just makes sense. Some of the stuff we're talking about, oh yeah, that makes sense. I can see why Congress would pass the law this way. I think this was just, I don't know, really great lobbying on behalf of military families and FMLA kind of advocates.
And to be fair, for those, the law is designed to protect the job of the armed services member, right? And so it would, to some degree, if you think about it, make sense that they shouldn't lose their job just because the contract went to a new company. They are essentially working in a particular position on a contract, and why should they lose their job as a result of that? So I can see how this came out. A lot of contractors don't understand that's an obligation. That's the same for the Family Medical and Leave Act. So in that, you are follow-on contractors are a successor under FMLA regulations, and that means that you could be working, you could have a contract for 1 month and an incumbent employee comes to you and says, hey, I need to go out on maternity leave, for example. And you might say, well, you don't have 12 months with the company, because as a refresher under FMLA, you have to have 12 months of continuous service or a certain number of hours on those, and a certain number of hours in those 12 months in order to qualify for that protected leave. The service with the prior contractor counts toward that qualification. So somebody could come to you on day 2 and say, I need to go out on protected FMLA leave, and you need to give them credit. If they worked for the last contractor for those 12 consecutive months, they likely qualify for FMLA leave, even though they didn't work for you for that prior 12 months. You should also be careful if somebody's out on FMLA leave and then you take over the contract. They could have, you wouldn't necessarily have to make them an offer, but you'd have to consider the circumstances when they return as to whether they're entitled to their position back.
And we received a question about USERRA that's kind of interesting just from a USERRA perspective. It's, do you need to hire an incumbent if the requirement has changed? For example, if a senior position is now a journeyman position. So in that situation, and the fun thing about USERRA is they use something that's called kind of an elevator promotion scheme. So the idea is that whenever that employee who went out on military leave comes back, they should be entitled to the same position that they would have been entitled to had they never gone on military leave to begin with. And it involves, in my opinion, quite a bit of guesswork sometimes, especially if the relationship of employees has changed and people are filling different positions. But essentially, you would need to consider, and this is hard too if you're a successor, how do you know how that employee would have progressed through the incumbent sort of workforce? You need to put on sort of, I guess, a creative hat and think, where would this employee be if these positions had not changed? Chances are you would not put someone who was a senior in a senior position in a journeyman position, maybe, but you have to look at the circumstances. And so that's sort of how the USERRA elevator principle functions.
And it could function in the opposite direction. They could still qualify. And the question you should be asking is, would this person essentially have been laid off in the normal course if the transition would have happened? So if that person was in that seat when you onboarded folks, would you have said, no, we're not going to hire you, or not? And you would, it's a pretty high standard, so you have to have pretty good evidence that that's what would have happened in that particular scenario. If you have less than 50 employees and are not covered by FMLA, do you have to still follow the rules essentially? And the answer is no. If you just don't qualify because you're under 50, then you don't have to follow it. Be careful, of just watching your numbers, because you can win and lose contracts in the busy time of year frequently. So, you don't want to be caught at 51, right? So just watch the numbers pretty carefully. The other thing to know is if you have a prevailing wage contract, like particularly the Service Contract Act, but it's also good to know service dates under the Davis-Bacon Act or construction contracts as well. But really, it's applicable to service contracts because the service date is so important for determining vacation and how much vacation people get under the Service Contract Act, and it's pretty rare that you see that under Davis-Bacon. So it's always a question I get. What if I never got the service dates for folks? So how do I know? And you need to do your research. You can have folks fill out applications and do employment verification checks. You can, ask people, and you can ask a number of questions to kind of figure out how confident are you. In my experience, folks are usually, they might be a month or two off, but usually they're pretty close to in range of what their service date was. But that will affect your price because it can affect how much vacation you have to give.
If you have a unionized workforce, sometimes you can also reach out to the union and they might have that information.
Yeah. Okay. What have you been smoking? If you can't tell, we had a little bit of fun with the titles in this one. So.
Yeah, that one. It was supposed to be funny, at least. So this gets into questions of drugs in the workplace. And as many of you know, federal contractors are required to comply with the Drug-Free Workplace Act. And the Drug-Free Workplace Act essentially says that you as an employer are not permitted to allow drugs or alcohol on the work site or while employees are engaged in work for the contract. And this is an interesting kind of requirement, especially in light of a lot of marijuana laws and policies that have been put into effect in recent years and months. And it interacts a lot with some of the, not ADA, because technically marijuana prescriptions are not protected under the ADA, but a lot of state ADAs have requirements that require that employers, and in some states, even federal contractor employers, have an obligation to consider certain disabilities that require the use of marijuana for medical purposes. And so as federal contractors, there's going to be a lot of development, I think, in the next couple years as more and more states start to legalize marijuana, either for medical or for recreational purposes. We're going to see some landmines popping up. One of those landmines is going to be pre-employment drug testing. And I should say off the bat, a lot of these considerations pretty much go out the window when you have a specific contract that requires, first of all, drug testing, and that prohibits, second of all, the use of marijuana at all for employees. So in those situations, of course, follow what your contract says. The problem is that a lot of contracts, to many's surprise, do not actually have strict requirements for drug testing and do not actually address whether employees are required to undergo drug testing for marijuana specifically. Often for contracts for sensitive positions, that will be a requirement, but most other contracts, it's not something you're generally going to see. So as a federal contractor, that makes it really important that you pay attention to what state laws are out there to make sure that you're not running sort of afoul of the state laws while thinking that you're protected by federal requirements when it might not necessarily be the case. And there have been a couple cases, I think in Massachusetts and Connecticut, where the courts there state courts have specifically said, just because you're a federal contractor doesn't mean you can fire someone who fails a drug test based on their use of medical marijuana. And so there are some sort of considerations that you have to take into consideration as you evaluate your drug testing. There are one state and New York City have limited pre-employment drug testing for marijuana. So most employers in New York City and Nevada are no longer able to conduct pre-employment drug testing. Both those laws have an exception for federal contractors for now. And so that's a pretty big distinction, but we're still sort of waiting to see what other states do in this arena. So it's really worth evaluating your drug testing policies and making sure that you're compliant with the states where you're operating.
You know, a number of years ago, the questions I would get were more along the lines of everybody is pre-employment drug testing and what's the best way to fire somebody when it comes back positive? Those are the kinds of questions I was getting. The last year or two, the questions that we get are, you know, Nicole, I am not going to be able to fill all these positions if I do a pre-employment drug screen because just the pervasive might be a terrible word, but a lot of folks out there are engaging in some recreational marijuana use, and certain types of jobs are harder to fill because if you have pre-employment drug testing. So the kind of tenor of conversations have changed over time, and I think that kind of tracks how the law has changed over time and how folks' view of this has changed over time. Don't misunderstand anything we're saying to mean that somebody who is on working time on a covered contract that's covered by the Drug-Free Workplace Act, because they all are, that they can use or distribute while on working time. That is not what we're saying at all. This is about, should we pre-employment screen? And as Sarah said, you know, if you have safety sensitive positions, people that are driving, people that are in construction, you know, there might be very good reasons to pre-employment screen, and where you're operating, it might be perfectly legal to pre-employment screen. But we are seeing a sharp decrease in the number of employers that pre-employment drug screen. They do reasonable suspicion testing, post-accident testing, and then safety sensitive testing, and they might have random where they have safety sensitive positions. But you want to chances are your drug testing policy has been the same for a number of years. Take a look at it, see what it says, and do you know what you would do if somebody tests positive, even on a reasonable suspicion test? Because the tests just aren't good enough to tell us right now, anyway, you know, when somebody might have engaged in the use of a controlled substance.
Generally, too, certain states have requirements about drug testing policies, and so if you haven't evaluated whether your drug policy complies with the state or with the contract that you're operating under, it's typically a good idea to just make sure that it tees up with those requirements.
So we have a couple of questions that I want to go back to real quick. One is, you know, we have a contract. This is, I think, particular to SCA, and the crux of the question is that we have a contract that does not have the SCA FAR provision in it or the sick leave provision in it. This particular company is paying the SCA rate, but is not paying the H&W, and they went to ask the contracting officer for a price adjustment under the price adjustments clause for the SCA, but this particular agency said they don't want to do it. Who is responsible for paying the H&W? Well, first of all, the reason why they're likely not paying it is because the correct FAR provisions are not in your contract. So in order for the SCA or the Davis-Bacon Act to apply, the correct FAR provisions must be in your contract. And if they're not, the government has no obligation to provide a price adjustment because from their view, the SCA doesn't apply. So it's not, you do not have to recognize the SCA just because you believe the SCA applies or it should apply. And you might be well right. I mean, my guess is if you have clerk type positions that it could be an SCA contract, but the SCA is a creature of contract. So in order to put the government on the hook for any type of price adjustment, the SCA has to be there in full, and that's the FAR provision plus a wage determination in your contract. So I would probably be asking, you know, should this apply? And if you have any question about whether the SCA should apply or not, that's one of those questions you really should be addressing pre-offer. And you can do that, you know, in a pre-award protest, a letter to the CO, we do this all the time. Because mistakes are sometimes made, and it's good to figure it out on the front end. In that particular position, if the CO ever or the Department of Labor gets wind of it and forces the contracting officer to put the right clauses in that particular case, then you would likely be entitled to some sort of price adjustment, although it's, again, very fact specific, and they're only going to give you a difference between what you're paying folks and what you're required to pay after the modification. So it's another reason to think about whether you want to pay more upfront. But that seems to be kind of a specific question. I am happy to, if you want to email me offline, maybe we can talk more about that.
Another question is about vacation for Service Contract Act. It's one of those doozies. So I think what they're getting at is this question of whether you have to credit the incumbent employees for vacation that they've earned under a predecessor contractor. And the way that the Service Contract Act is written is that you're crediting vacation based on the employee's anniversary date with the contract as a whole. So as long as it's a similar contract where they performed work, their anniversary date is going to be whatever date they started on that original contract with the predecessor or the contractor before the predecessor. And so that's why it's important to make sure that you know their anniversary dates, because yes, you could be responsible for those 3 weeks and more of vacation, depending on how long they've been there and depending on the wage determination.
Now, if it's not an SCA contract, then you don't have to worry about it. So if it's a contract for construction that doesn't have vacation requirements in the wage determination, or if it's just a general contract that's for professional services or supplies that are just not covered by prevailing wage law, there is no particular rule that says you have to grant that service time for an incumbent under your policy. You can start people from scratch. Now, you can decide from a policy perspective if that works for you or not. I would probably make sure the language in your vacation policy is pretty clear as to what folks get, that it's not service on a contract, it's service with the employee, the employer specifically, because state law generally, for most states, vacation is considered wages depending on what's promised in your handbook or offer letter. So you want to be careful about what those documents say, because if an employee thinks that the vacation is promised to them based on a service date, or that, you know, this often comes up as to whether you have to pay vacation out or not at the end, that often is going to come down to what language is in their paperwork. If you don't have anything nice to say, you know,
don't ask it in an interview.
Don't ask it in an interview. You know, it's always a good idea to have a game plan when you're onboarding folks. You know, make sure your team, if you know that it's going to be, if you know there are going to be some tense moments, you know folks are going to be taking a pay cut. You know folks are not going to be getting the same benefits as they got before. It's always a good idea, depending on the number of people that you're onboarding or talking to in like pre-meetings, to have some talking points. How are we going to message this? What does the company want to say to these folks? You also want to be thinking about if you have any concerns about security clearances. What do I mean by this? Oftentimes we'll get questions about how long it takes and what an investment it is to take folks through the security clearance process. And from time to time, we'll be asked about, what kind of questions you can ask somebody in order to ensure that if you sponsor them through that clearance process, that they'll be successful at the end of the day. The questions on those security clearance kind of questionnaires, what the government asks your people, many of them are just plain illegal to ask, right? Or can get you into trouble if you ask. So for example, unless your contract specifically says somebody has to be a US citizen, you should not be asking about citizenship. You should be asking about authorization to work in the United States. You generally shouldn't be asking about someone's finances pre-offer at least. And then when you do ask, it falls under the Fair Credit Reporting Act. Obviously you don't want to be asking about protected class issues, religion, family places of origin, things like that can get you into some hot water. And so you want to be careful about when you ask about certain things, how you ask about certain things. And we certainly understand and sympathize that things like security clearances can take a lot of time and money. We need to get out ahead of them. And we can certainly discuss strategies about how to take those into consideration. You just want to be careful you don't have a document out there that waves in the air and says, I'm asking questions that I should not be asking. It's generally not something we want as Exhibit A to a lawsuit.
You also want to consider, again, with the union hat on, you want to think about whether it's a unionized workforce. And there are certain things you really need to get right when you're walking into a unionized workforce. And I would not recommend figuring these things after the fact, because after the fact, in some cases, not to be gloom and doom, it's already too late. One is that falls in line with sort of those general requirements around interview questions. Don't talk badly about the union and don't talk badly about union membership. You really shouldn't be asking whether people are members of the union. When you walk onto a work site that's unionized, not everyone is going to be members. It's still something you want to stay well away from, because under the National Labor Relations Act, there are strong protections for employees. Two other kind of things you want to think about is, so we talked about successorship ideas with the FMLA and with USERRA. There's also a successorship idea when it comes to the NLRA, but it's different. Successorship is just something that, depending on the law that you're talking about, it has very different requirements. So under the NLRA, when you go in and you hire essentially a majority of the predecessor's workforce, you have an obligation to bargain with the union. There is something that is called a perfectly clear successor, which essentially means you walk in, act as though you are going to have all the same terms and conditions as the incumbent, and after that have an obligation to sign on to that CBA, the Employees Collective Bargaining Agreement that's already kind of there for the workforce. If you're just a plain old successor, you don't have an obligation to sign on to the CBA. But if you come in and do not make clear that you're changing up terms and conditions, it's possible that you do have an obligation to sign on to that CBA. And you don't want to be in that position, because most CBAs have things that can be incompatible with kind of your type of relationship. There are a lot of considerations when it comes to government contracting that you want to make sure that you get it right, so that you can get price adjustments, so that you can kind of achieve the steps that you need to achieve to perform your contract. And so in those situations, if there is a unionized workforce on board, you want to make clear that you are going to negotiate with the union if appropriate, but you're not necessarily going to just sign on to the same terms and conditions of employment. That kind of goes into the next point, which is, don't refuse to bargain. Don't say you're not union. Don't say, oh, well, I don't know, don't believe in unionized workforces. Those things are going to end up with a ULP before the board, and
or we don't provide union benefits, or we don't do XYZ. This is where the talking points will really help you out, because you don't have to say that you are going to agree to any of those things. In fact, at the point where you're onboarding, you might not even know if you will have a full bargaining unit. What I would tell you is that if you are slightly uncomfortable with some of the concepts that we're talking about here, and you are thinking about bidding on work that has a unionized workforce, it may be well timed that you got into that game, but there's going to be some learning you need to do before you start working in this world, because completely, something that can be done and done well, but it is not the same as what you're usually used to working with. And we do have another training for labor training. So if you think you need some labor training, reach out to us and we're happy to provide some basic training to your folks. But that's where you really get into trouble, is when you have folks that are not used to dealing or working with unionized workforces, and something is said during the meetings prior to offer letters, or discuss, union rep calls and wants to have a conversation with you, and you say we're not a union employer and hang up the phone. Those types of, you're going to get them really angry really quickly. So on the other side of that coin, you should be careful before you just say, well, there's a CBA already in place, I'm just going to sign this document that says that I will agree to all the same terms and conditions. You should be very careful about what you might be agreeing to in those particular circumstances. So it's important that you understand all of those nuances.
And unions don't always understand sort of the quirks that can go along with a government contract. I mean, some of them get them really well and are great resources, but some of them also need to be educated to a certain extent. So just because they've been here doesn't necessarily they know all the rules and tricks of the road. So just make sure that you're finding the right resources that you need. We received a question that I think harkens back to the prior slide about asking about citizenship. And the question is, if you have a contract that specifically says someone must be a US citizen, are you allowed to ask the question? I think in that situation, one good way to sort of make sure that you're weeding out people who aren't eligible would be to put on your application that the position requires a US citizenship, if that's actually the case.
Or the job post, you can even put under, a lot of times job postings are broken out by required credentials and preferred credentials. And under those, you can say government contract requires US citizenship. I would make it clear that it's a contractual requirement so that you don't get any raised eyebrows out there that says, wait a second, they can't be asking me about that. But yes, in short, you can discriminate on that basis when your contract specifically requires it. So what about offer letters? Offer letters are one of those documents that should conceptually be very easy and can get you into a lot of trouble if you don't have done right. And every year we have a couple of cases that demonstrate to us why it's really important to make sure that you get the offer letter the way that you want it, and that you understand when changes have been made to it and whether those changes are appropriate or a good idea. Because what might be a good idea to somebody who is trying to recruit somebody and get them on board, your HR team or your legal team might be waving, in the stands and saying, please, please stop. So the offer letter, you need to make sure you have things like good at-will language and contingencies. So does somebody have to pass a background check? Does somebody have to take a drug test? Is this contingent on approval by the government? So does the government have the right to give a thumbs up or give a thumbs down? Are there,
on contract award?
Yeah. Is this an offer letter that you are going to be using in a response to a solicitation, and there's really not a position for this person yet unless the contract is awarded? So you need to make sure you have that kind of stuff in there. You need to make sure that your exempt, non-exempt class and classification language is correct. So is this person exempt or non-exempt? I really dislike when I see an offer letter that says you will be paid on a salary basis and your hourly rate is $25 an hour. If you're on a salary basis, you have an annualized or weekly or bi-weekly salary that doesn't change from week to week. You do not have an hourly rate. And I understand that sometimes as a government contractor, you've done the math, you've taken the salary divided by 2080 or whatever the case may be, but don't do that. It generally makes me really, really nervous when I see that.
Why shouldn't they do that? That might be a good.
Yeah, so you should not, thank you, Sarah. You should generally stay away from that because it calls into question the exemption. So if you're investigated by the Department of Labor and it starts looking like somebody is paid on an hourly basis, meaning you might deduct for, absences, or it looks like they get an hourly rate as opposed to a salary, then you're going to lose that exemption. And if they incurred any overtime, you're going to have to pay it. And that they can go back 2 or 3 years on that. So it can be very expensive. Not to mention that a lot of classifications, particularly in the administrative exemption, are really gray areas. They are hotly contested right now. Just to give you an example, a Department of Labor investigator is a non-exempt hourly employee. So when you are talking to an investigator and you're trying to make the case for an exemption, you are running up against that hurdle. So you need to make sure you understand that. Another thing to note is if you have enough employees and to qualify under the WARN Act, you should have language in your offer letter that says that this job is only intended to be for the duration of this particular endeavor or contract, subject to the at-will language. We can still terminate you whenever we want. But the WARN Act basically says that if you're going to lay off a certain number of employees, and states have WARN Acts too, so if you're going to lay off a certain number of employees, then you have to give them notice. And sometimes you don't know before you don't have enough lead time by the time
so generally it's a month or two, and you might learn
15 days ahead, or there might be a protest option still out there, or whatever it is. If you have specific language in your offer letter that limits the duration of employment, you can actually qualify under an exemption to the WARN Act. So it's a good thing to just start putting in your offer letters and get that language down. So if you ever run into that issue, you don't have to worry about it. There are a couple of other bells and whistles depending on the types of contracts you have that I like to see in offer letters, or some commitment or attestation that there are no non-compete or non-solicitation obligations, things like that. But you should be looking at your offer letters and scrutinizing them carefully. Is the takeaway there.
I don't know if we mentioned this, but put at-will language in there. As long as it's an at-will employment relationship, generally we don't like offer letters that look like contracts. We don't like offer letters that tend to offer a term of employment. And so that's right, you mentioned it with the WARN Act, but at-will language, it can really help you if an employee is trying to act as though they were entitled to employment for longer than whatever was ultimately the case.
And the last thing I'll note on offer letters is sometimes you have somebody that you really want to bring on board, so you'll start talking about things like signing bonuses and, things that you don't typically offer. And when you offer those, you need to make sure that if you don't intend to pay them if they don't get through an introductory period, or you don't intend to pay them if a contracting officer removes them, that you have the terms of that bonus or sign-on bonus in that letter. Otherwise, you might be on the hook to pay them that 10 grand, even if they end up not working out.
Right.
All right, we have like 2 minutes left, and there was another question or two. One was, can you clarify when an employer can deduct from an exempt employee's wages? The circumstances are very limited, but you can deduct them for full day absences for personal reasons. So somebody decides they want to go to the beach on Friday and does absolutely no work, doesn't check an email all day, you can deduct for that full day absence. For sickness, in a full day absence, if you have a PTO or sick leave policy and they've run out of sick leave and they need a full day absence, you can deduct from that. If you suspend them or discipline them,
or violations of company
policy
policies.
basically, then you can deduct, but that's about it. Oh, and if you have partial work weeks. So if you start somebody on a Wednesday, you don't have to pay them for Monday and Tuesday.
Right, at the beginning and end of their employment.
Yeah. Just be careful of those, partial day deductions. You can use your paid time off or vacation policy to fill in gaps. So if somebody is out 2 hours in an afternoon, you could force them to use their PTO instead of.
And you can also allow employees to go into the negative to sort of capture so that they're not on leave without pay. But we had another question that was sort of asking, can you deduct from an exempt employee who works fewer than 40 hours a week? And unless you've hit on one of those exceptions that Nicole just discussed, you really can't, because it runs the risk of turning them into an hourly employee.
Then they're hourly. And frankly, I'll tell employers all the time, if they're never running into overtime or you're very good at carefully managing their overtime, make them hourly. You get to choose whether you take advantage of the exemption or not. There's no rule that they have to be salaried. So unless it's like an SCA contract and you don't want to pay like the SCA H&W or something like that, if it's just a general professional services contract, it might make sense for you to make folks hourly if they're consistently working under 40, or you can make them use their paid time off. Let me see if there's any other questions that we can just answer quick. It is 3 o'clock. Is it binding to the candidate and the employer when you win a contract? Well, what I think what you're getting at is, do I have to hire that person if you gave them an offer letter and then the contract is awarded? That's why you really want good at-will and contingency language in your offer letter, because in certain circumstances, if you've got the right contingency and at-will language, there is no binding contract unless you make it be a binding contract. Let's see.
I'm not sure if this got lost, but we did mention very quickly that the midweek pay for exempt employees doesn't have to be for the full week if it's at the beginning or the ending of employment.
Yes.
Got a question about that. Just wanted to clarify.
So it's 3:01 and we've worn out our welcome. So thank you for joining us today. There might be a few questions that we weren't able to get to, and we will respond to you via email. Feel free to reach out to us if you have any questions about our content today. Thank you for joining us and have a great afternoon.
Thanks, guys.